Welcome to this explainer. Listen, if you are a real estate investor in a Kansas City metro area, chances are you did not buy your very first property inside an LLC on day one. And honestly, that is incredibly common. Most investors close in their personal name, sometimes a residential lender requires it, or maybe forming a legal entity just feels like a complicated step to put off until later. But as your portfolio grows, later eventually arrives. Usually it happens after a specific trigger, like a really difficult tenant incident, the purchase of a second rental, or a serious sit-down conversation with your CPA. At that point, the question completely stops being whether you should use an LLC and it becomes a purely mechanical question. How do you actually move a property you already own into an entity without creating a massive headache? Today, we are breaking down the exact blueprint for mechanically transferring your Kansas City rental into an LLC, drawing directly on the expertise of Alpine Property Management Kansas City, or Alpine, a property management company serving Kansas City investors since 2013. Before we get into the mechanics, we need to explicitly state that this explainer provides an educational blueprint only. It absolutely does not constitute legal or tax advice. Every single investor's situation is entirely unique, so you should always consult with your own legal and financial professionals before making structural changes to your real estate portfolio. Here is our roadmap for today. We will cover the order of operations, navigating the due on sale clause, Missouri versus Kansas rules, choosing a deed, crucial post-transfer updates, and making the right choice. Section 1, Order of Operations, getting the sequence right. I literally cannot emphasize this enough. The mechanical order of a property transfer truly matters. Legally speaking, you are conveying real property from yourself to a completely separate legal person, even if you control 100% of that new LLC. The sequence must be precise. Form the LLC, get an EIN, open a bank account, and only then prepare the deed. This non-negotiable sequence is where so many do-it-yourself investors trip up. You absolutely cannot deed a house to an entity that has not been officially formed yet. Doing so creates a serious title defect. Skipping this proper order usually surfaces years later when a title company flags a break in the chain of title during a future refinance or sale, and it is a mess to clean up. Section 2, Navigating due on sale, dealing with active mortgages. For most investors who own a property free and clear, this entire process is mostly just a paperwork exercise. But if you have an active mortgage, you are going to face a critical hurdle. Does transferring a rental property into an LLC trigger the due on sale clause? Well, the honest, data-driven answer is that it certainly can. Most residential deeds of trust give the lender the contractual right to call the entire loan balance due immediately when the title transfers to a new owner. And here is the kicker. This clause survives the transfer even if you are the sole member of the new LLC and you continue paying your mortgage perfectly on time. Now you might be thinking, what about federal law? The Garn-Sell-Germain Depository Institutions Act does limit when a lender can enforce that due on sale clause. But you have to look closely at the statutory exemptions. They cover transfers to a relative on the death of a borrower, transfers between spouses, transfers incident to divorce, and transfers into certain revocable living trusts where you keep occupancy rights. Did you notice what is missing? A transfer into an LLC that you personally own is not on that list. Wholly owned LLCs are completely unprotected by this federal law. Now, some agency loan servicers do publish their own exceptions for entity transfers, provided you keep your personal liability intact. But these exceptions are program-specific, and they can change without notice. Therefore, you must get written permission from your specific loan servicer before recording anything. Seriously, do not guess on this step. Section 3, Missouri versus Kansas rules, crossing the state line. As we know, the Kansas City metro area famously straddles the state line, and the procedural differences between these two states are incredibly important to get right. In Missouri, you file with the Missouri Secretary of State and record deeds with the County Recorder of Deeds, like in Jackson, Clay, Platte, or Cass counties. In Kansas, you file with the Kansas Secretary of State and record with the County Register of Deeds, typically in Johnson or Wyandotte counties. The deed quirks are actually pretty fascinating. In Missouri, your deed must state your marital status on the document itself. A missing marital status is a primary reason an out-of-state owner gets their Missouri deed rejected on the very first submission. Kansas has no marital status requirement, but it generally requires a specific real estate sales validation questionnaire to accompany the recording. The really great news for investors in both states is that neither Missouri nor Kansas charges a real estate transfer tax. Your only cost is the recording fee. In Missouri, that is set by state statute at roughly $24 for the first page, while Kansas hacks their fees by the individual county. Section 4. Choosing a deed. The instruments of transfer. Okay, so once your LLC exists and your lender is totally on board, You need a written document to actually convey the real property to the new legal entity. You basically have two ideal options for this type of related party transfer, where no money is actually changing hands. First is a quitclaim deed. This simply conveys whatever interest you currently hold with absolutely no warranties. This is often perfectly sufficient since you are both the grantor and the sole member of the new LLC. Alternatively, you could use a special warranty deed. This warrants only against defects that arose during your specific period of ownership. This is a really great middle option that closing attorneys often prefer if you want to preserve a stronger warranty for a future sale out of the LLC. As a quick side note, a general warranty deed is an odd choice here because it basically has you personally warranting clear title going forward on a property you no longer actually own. Section 5. Crucial post-transfer updates, the invisible gaps. These updates are where investors make the most dangerous mistakes. They're like hidden trapdoors that surface only when a crisis hits, long after the deed is already recorded. First, you absolutely must update your owner's title policy. Many standard policies have a continuation of coverage provision for wholly owned LLCs, but it is not a guarantee. You need to send your new deed to your title company and ask them directly if the LLC is covered. Second, change the named insured on your landlord insurance policy to the LLC. If a pipe bursts and your personal name is still on the policy while the LLC owns the house, the insurance company is going to raise an insurable interest question right when you need a payout the fastest. Finally, execute a lease assignment and update property management agreements. Assign the lease to the LLC so the entity actually has the legal standing to collect rent or file an eviction, and ensure rent deposits and tax reporting flow to the correct legal entity. Section 6. Making the right choice, the 80% rule. This brings us to the ultimate educational takeaway regarding how to manage this transition successfully. Marcus Painter, the founder and owner of Alpine, puts it exactly like this. He says, recording the deed is the easy 20% of this project. Updating the paper trail around it is the harder 80% that actually protects you. That quote perfectly cements the reality of real estate investing. The LLC structure itself is not just some magic liability protection. It is only as strong as the underlying paperwork. If you leave your insurance, your lease, and your property management agreement in your personal name, you leave an invisible gap that entirely defeats the purpose of forming the LLC in the first place. To wrap things up, transferring your Kansas City rental into an LLC requires strict adherence to state rules, proactive lender communication, and a rigorous update of your paper trail. If you take the time to do it methodically, you will protect your investments for the long haul. I want to leave you with one final thought to mull over. Ask yourself, is your current asset protection plan actually fully executed on paper, or are you just hoping those invisible gaps never get tested? For help managing your Kansas City rental property, call Alpine at 816-343-4520 or visit alpinekansascity.com.